Good day. My name is Dennis Bailey. I'm General Counsel for the Alabama Press Association. This is the first of what we hope will be a series of podcasts, webcasts that will address subjects that come up on the media hotline that may be of general interest to you, the members of the Alabama Press Association. I chose for today what I hope is a pretty common situation that you face, and that is what to do with a letter to the editor. Now, the legal concept of a letter to the editor is pretty simple, and that is when you take a letter written by a third party and you publish it in your publication, you own it. You are responsible for what it says. You have no defense to say that I was just republishing something else that somebody else wrote. You have to view letters to the editor as if you wrote them or members of your own staff wrote them and edit them accordingly, especially when they make comments in the letter that are potentially defamatory against private individuals. So we got a letter to the editor recently from a client, written by an interesting person who was an inmate in the county jail after being recently convicted of 3 felonies. The writer of the letter was upset about the conviction and said that the witness against him, a private individual, committed perjury, that the district attorney was guilty of unethical conduct, and that the lawyer that represented him was incompetent. Now, all of these should have been red flags, particularly the statement that a private individual committed perjury, commission of a crime, and in most cases, if we had gotten this letter, we would simply tell you not to publish it or remove those kinds of statements from the letter. Unfortunately, in this case, the cat was out of the bag. We were called after the letter was published and after complaints came in from the subjects of the letter about being accused of bad acts. So that was a situation where we had to take action to retract the statements in the third party's letter to the editor, because although the district attorney is a public figure and would have to prove malice by the newspaper, the individual mentioned in the letter to the editor was not a public figure and need only prove negligence. And the circumstances here were such that someone might conclude that the newspaper failed to do due diligence. Moral of the story: you've got a legal hotline plan that is part of your membership dues. You ought to use it. We're here to help you avoid these kinds of situations. We do pre-publication reviews of articles all the time and a lot of letters to the editor. You can edit the letters to the editor and to make them non-defamatory in some cases. In some cases you can't, and you just have to throw them away. You have no duty to publish a letter to the editor, but once you do, you have to take care because, as I said earlier, it's on you now when you do that. So keep in mind that we're here, that Press Association provides us at no extra charge to you, and that you should use the media hotline for questions like, do I run this letter to the editor? Hope this has been of help, and talk to you next time about another issue next month.